Asylum seekers do not pose a threat to South Africa's border security, says Home Affairs Minister Leon Schreiber. Home Affairs Minister Leon Schreiber has moved to reassure Parliament that asylum seekers and recognized refugees living in South Africa do not pose a threat to the country's border security, despite ongoing challenges in processing appeals and certification applications. The minister was responding to parliamentary questions from MK Party MP Bibi Mohammed, who sought clarity on backlogs in asylum, refugee and permanent residence applications, and whether delays in the system were undermining border control and service delivery. Schreiber told Parliament that there is currently no backlog in the processing of new asylum applications or in the review of asylum seekers' claims. As of December 1, only 13 asylum applications remained unadjudicated, a figure he described as manageable and not indicative of systemic failure. However, he acknowledged significant pressure points elsewhere in the refugee management system. The Standing Committee on Refugee Affairs currently has a backlog of approximately 3,700 cases awaiting decisions on Section 27 certifications. These certifications are required for refugees who wish to apply for permanent residence in South Africa. In addition, the committee is dealing with 7,829 cases related to the possible withdrawal of refugee status. A far larger challenge exists at the Refugee Appeals Authority, which is facing a caseload backlog of more than 151,000 appeals, including cases that have been ring-fenced for special handling. Schreiber said this backlog does not affect border security, as asylum seekers with pending appeals are legally required to remain in South Africa under the conditions of their temporary permits. These individuals are bound by the laws and the Constitution of the Republic of South Africa, Schreiber said, adding that compliance with permit conditions is enforced while cases are under review. He further explains why permanent residence applications are not backlogged, following the clearance of outstanding cases earlier this year. Only appeals against negative permanent residence decisions remain outstanding, and these are currently regulated under ministerial directive. Schreiber stressed that South Africa's obligations as a signatory to the 1951 Geneva Convention require the state to provide protection and basic services to asylum seekers within its borders. He cautioned, however, that prolonged delays in finalizing appeals and certifications can place pressure on public resources. According to the minister, delays often lead applicants to seek judicial intervention to compel decisions, which result in increased legal costs for the department. He added that unresolved withdrawal cases allow individuals who no longer qualify for protection to remain in the country longer than intended, continuing to access state services. To address the backlog in asylum appeals, Schreiber said the Department of Home Affairs has been implementing a backlog project funded by the European Union since January 2024. This initiative has been expanded through a surge initiative developed in partnership with the Refugee Agency and the Refugee Appeals Authority. As part of this effort, 43 practicing advocates have been recruited in Pretoria to assist with appeal adjudications on a part-time basis. The goal, Schreiber said, is not only to reduce the existing backlog, but to prevent future accumulation of unresolved cases. Looking ahead, the department plans to fully capacitate Refugee Appeals Authority officers across all 5 regions. This long-term strategy aims to align appeal processing with the department's 180-day adjudication target, from initial application to final appeal outcome. Schreiber said meeting this target would ensure that genuine asylum seekers are not left waiting indefinitely for decisions, while also safeguarding the credibility and integrity of South Africa's asylum system. He concluded by reiterating that the presence of asylum seekers and refugees should not be conflated with border insecurity, arguing that effective administration, rather than exclusion, remains the key to maintaining lawful and orderly migration management.